Well, let me ask you another way. If a city did, in fact, under the current circumstances, enact an ordinance that allowed for some kind of distribution point, would you support that as it stands right now? If some city was doing that, and I know there's some, do you think that the state can stop that from happening?
Well, we have some control, not complete, because of the Home Rule Act. We can't tell municipalities how to do their entire job, but we can set certain guidelines and at least try to encourage a more thoughtful approach, one that would, through guidelines, it's not so much incentives, but kind of a model code saying maybe industrial areas are fine, commercial areas might be fine, but that's something we'd have to work on. And I'm sure we'll have quite a bit of input from the municipalities before that bill ever passed.
One of the premise that I understood the Livonia bill to be based upon was, that it is preempted by federal law, or that no behavior that is illegal, city, local, which of course raises the states' rights issue. In that regard, there's a lot of talk and a lot of topic about the federal government's position and kind of flexing their muscles in various states that are medical marijuana. What is your view about that? Do you think that it's appropriate for the federal government to, for example, be raiding, dispensaries in California, or, invading, what they're doing now? They're shutting down various places. I think in Colorado. I mean, their issues were that they were close to schools, I think, which no one's against.
The IRS has come to Colorado dispensaries and California dispensaries under 280E.
Right, and this is after the, of course, the states had, set up regulatory systems and allowed, that behavior to go on. And in fact, in Colorado, I know for certain that, states had received tax proceeds from, the dispensaries that they'd licensed, and the federal government, I know, even received, federal tax payments for the sale of cannabis. So, what are your thoughts on that? I'm just curious.
Well, we would not be working on this legislation, and we wouldn't be on the eve of having public hearings regarding it if we didn't think we had the right to pursue the legislation and to have medical marijuana here. But ultimately, I would imagine someday there's going to be a court case that will decide our rights versus the federal rights. I think we have the right to have medical marijuana. I think that our voters have spoken, and they made a constitutional amendment. And then that, therefore, gives us as office holders the right to pass legislation. It gives our citizens the right to use medical marijuana. But one of the most difficult parts of our discussion on any aspect is really the shadow of the federal government, and whether or not they're going to enforce federal laws. It's a prohibited narcotic under federal law. So it's a mix, but I'm comfortable. Our committee is comfortable, and ultimately I think we'll all be voting on bills and legislating, and we think we have the right to do so.
Independent of the federal position, you're saying, right? That's not
correct.
You're not contemplating that per se or it's not limiting your view on how you would proceed.
How does that square with the Livonia ban then?
Wait, to go back to the first question about how I see the feds coming in, where it's really difficult, in my opinion, is as we try to address distribution. That has been the most difficult conversation as we talk to interest groups, individuals, police, and so on, is dealing with the fact that let's say one model might be to have large growing areas, large farms, centralized distribution centers. The problem with that is the larger the operation, the more plants you have, and the higher the penalty is underneath federal law. And so how do we, I don't even know if we're going to be able to, but how can we design something under the state and then give a private sector individual any assurance, I don't think we can, that their operation is going to satisfy federal law? I mean, that's where our discussions get really bogged down in terms of do we have confidence that we have the right, our citizens have the right at the state level to move forward on adopting a medical marijuana constitutional amendment? We do. We wouldn't be acting in this manner. Now, not everyone agrees with that, but there are enough that do, that allow us to have the opportunity to bring this forward and take a look at the legislation. But trying to define something that's going to bring in private sector individuals or even local municipalities, that's the tough part, because they can look to federal law. We can't force them to pick between the two, not at the present time, not until we have a Supreme Court ruling, I suppose, indicating that one law is higher than the other. So I guess, kind of segueing into the local issue, the city has the right at the present time under the court rulings as I know them, under the law as I know it. I'm not professing to be an expert in all of it, but they have the right to make that decision that federal law prevails. Someday somebody will challenge that, whether it's here or some other city.
Sir, would you consider introducing a memorandum requesting the federal government to match our policy? To change their policy to match ours? Just a memorandum in the legislature.
I haven't. It's the first time I've ever been asked that. I have to think about it. On occasion we'll do a resolution regarding existing law. We might say as a legislature we encourage you to continue a law or amend it. I'd have to think about that.
And that would be representing the people,
Okay, so just as we talk about this federal issue, one of the other concerns of the community has been the gun issue. The ATF administrator, put out this memo declaring that cannabis patients because cannabis is still a controlled one substance, it's considered anyone that's using it as a drug addict, and and now there's places on the applications for guns that have you declare whether you're a patient or not. A client of mine told me that they went to the gun range, and to sign in, you had to declare whether or not you were a medical marijuana patient or not, and if you were honest on the form, they would not let you shoot at the gun range. That was a story I heard today. And people are scared out of their minds, and I know I don't know if you had much experience with criminal law, but when you are charged with a felony and there involves a weapon, and I'm talking about just being anywhere in the house, it could be a handgun that for protection, it could be hunting rifles, and they charge you with this felony firearm, which is the use or purported use of a weapon in the commission of a felony, that being that their door wasn't unlocked, or they had 13 plants, or 2.6 ounces, and now you have a 2-year mandatory gun charge that if you're convicted of, the judge cannot give you probation. And you've got these people that are hunters, or they have CCW permits and medical marijuana permits, and now they are in a very, very high liability situation. Is that discussed at all? I mean, is the legislature aware of the stress on the Second Amendment believers? No,
I didn't know anything about the ATF memorandum. It's not covered. I'm just going through the list, even of the Senate bills, and I don't see anything that addresses that issue.
Or I just by your reference, I know Oregon has made some. There was an issue. I think they actually had a ruling by their Supreme Court
that medical marijuana users did have Second Amendment rights.
Yeah. That's a really hot topic. I've only because I get so many calls in my office, the number of hunters that are in a quandary of whether or not they're going, how they should fill out their, application, and their, and whether they're going to be subject to perjury charges through the federal government, and whether they have to abandon their medical marijuana card so they can, have a weapon in their house in case there is a burglar. Really difficult decisions for the community.
Mm-hmm. Mike, we just haven't had that conversation. I'm making notes, though, of these things that we've not heard, and we can add that into the discussion.
Appreciate that.
How do you feel about medical marijuana patients having Second Amendment rights?
Well, they certainly have Second Amendment rights. I mean, all of our citizens do. So I would agree with their Second Amendment rights.
Excellent. Thank you.
Let me ask you this. There was I'm sure you spent a lot of time looking at the act itself, and I'm sure you're aware of many of the disputed areas that deal with the different types of purported allowable transactions and whatnot. Do you think that the act, as it stands right now, protects primary caregivers with providing medicine to patients outside of the 5 that they are connected to through the registry program?
No, I don't think so. I think the Act really does limit the caregivers just to the 5 that they have.
Okay. As far as the purpose of interpretation of the Act, and this is a question that comes up a lot. Just when what's someone supposed to do that is beginning to be a caregiver for a patient? Like, how would they go about under the existing law then to acquire seeds or whatever the starter clones are to begin growing? I mean, what's the explanation, if you would, in those instances? How does someone get started?
That's a tough part, and that is part of our conversations on this legislation. The whole seed issue and how you get started is very troublesome. And I don't have an answer to that. None of us do, unfortunately. When we start to take a look at some of these bills in a couple of weeks, we'll begin taking up a few of them on the 16th, dealing with some of the relationships, in particular that between a doctor and a patient and a caregiver and a patient. Part of the discussion will focus on that. How do you legitimately get started as a caregiver? Because the current language doesn't get you there.